I've been working on the Assange case for 6 years now, and there's been a lot of talk about the Espionage Act, and so I thought I heard it all until I read this article by Bruce Afran, a professor of law at Rutgers, and he's got an incredible resume. But I'm going to let Joe introduce him. Joe, are you there?
Yes, I am here.
All right, so give us a little background on Bruce.
Well, I just say Bruce is a professor at Rutgers University. He could fill you in if he wants on the longer bio on some of the important cases.
Yeah.
He's covered, but Bruce and I were having lunch about a week ago or so back in Princeton. I'm in Mexico City, and I ducked inside of a church to get a quiet place. So Bruce and I had this lunch, and we started discussing the Assange case, and he came up with some very novel ideas that I'd never heard before, including the first issues about the First Amendment and the Fifth Amendment, as well as the questions of jurisdiction and whether Assange is a fugitive or not. The First Amendment issue, the Espionage Act charges Assange with unauthorized possession, unauthorized dissemination, or transmission of defense information. But Bruce is arguing that the First Amendment authorizes him to have that.
You're in Mexico City, and I mean it's in the papers, or at least online, that John and Gabriel Shipton are there. Can you tell
That's
us?
Correct. Yes, I went to a press conference yesterday at the House of Deputies, the Parliament of Mexico, and they met with the President of Mexico, Obrador, for 1 hour, and he reassured his support again for Julian Assange, and then a group of about 30 deputies stood on a platform at the press conference area and spoke about why they've signed this letter to Joe Biden, and Gabriel and John spoke at the press conference, which I covered and which we'll be posting that video once we get English subtitles for it. And it was an extraordinary moment. I saw John then later at a new museum that was opened, and there was a crowd of reporters around them and a welcoming committee. They're being treated like stars here, whereas in the U.S., of course, we know that is a different story, and in Europe. But here in Mexico, Julian Assange, at least the people who were around John and Gabriel, really do understand the issue. And Bruce, if we get him, will help us.
He's on right now.
Very good.
Okay,
very
go
good.
ahead. Why don't you go back to that question?
Bruce, I did a long introduction and explained how this piece came about, and I mentioned that you've written about the First and Fifth Amendments, about the question of jurisdiction, and the issue of whether Julian's a fugitive or not. So, if we could start with the First Amendment, the Espionage Act says he's charged with unauthorized possession of defense information. You're arguing that the First Amendment actually authorizes his possession and dissemination.
Well, that's exactly right. Randy, good to be on the show. Thank you. Joe, you're hitting the right issue. The Espionage Act penalizes such a broad range of information, any information relating to the national defense that could injure the U.S. or give advantage to a foreign country. That's virtually anything that a reporter might get their hands on concerning national defense or foreign policy. So to criminalize this is to criminalize daily journalism. To be blunt about it, there's no reason under the theory the government wants to jail Assange that the editors and reporters of the New York Times should not have been jailed for publishing the Pentagon Papers, which was also classified. So it's a major threat to journalism, the very nature of this prosecution. And what I think the government overlooks in its rush to judgment is that WikiLeaks and Assange were acting no differently than the New York Times. They were journalists.
Right.
Well, in fact, the Obama administration declined to prosecute Assange for that very reason. They even called it the New York Times problem. Bruce, what about the Fifth Amendment? This is completely novel. Other people have written about Assange and the First Amendment, although it's unique the way you put this conflict between the First Amendment and the Espionage Act in such a way that the First Amendment would authorize him to have the defense information. But the Fifth Amendment, and you give some good examples, explain how the Fifth Amendment violates Assange's due process.
Well, Joe, it's fascinating. There's an interrelationship. Just as this is overbroad and would reach a whole vast array of First Amendment activity, for the same reason it violates due process under the Fifth Amendment. Basically, the Fifth Amendment says there must be clear notice of what is a crime before one can be charged. And the Espionage Act has to follow that rule also. We don't have vague crimes. That's what dictatorships use in order to ensnare their opponents. So the Espionage Act is the model of vagueness. Information relating to the national defense. So if you're in possession of that, you could be committing a crime. It doesn't even say classified information. It doesn't even say information that will aid our enemies. It simply says information relating to the national defense. So how do you know when you're in possession of the information that could lead to prosecution? There's no notice. There's no clear notice. Then you go further, and it says where that information will cause injury to the U.S. or an advantage to a foreign country. So again, you have no way of knowing when you will trespass against this law. In fact, I could have been prosecuted because in 2006, when I challenged with Carl Mayer a statute dealing with domestic surveillance and phone records, we cited a source whose name was kept private, who said the NSA asked him when he worked for AT&T to develop a listening center of AT&T calls. Well, by the very definition Assange is charged with, I could have been prosecuted for doing my work as a lawyer. The exact same vague statute could have entrapped me into being prosecuted as a defendant. So that's what we mean when we say the Fifth Amendment is violated. There's simply no notice as to when you're committing a crime or when you're acting as a lawyer, a writer, journalist, or even as a citizen.
Bruce, we were talking earlier about this, and the original intent of the Espionage Act when it was passed in April, May, after the war was declared by Wilson, it was designed to go after dissent. Essentially, and the language in it, they didn't snare any German spies. Was that what it was all about? Just stifling dissent at home against this war?
It's fascinating. We think of ourselves as a constitutional country today, but back at the time of World War I in 1919. Our First Amendment law didn't really exist. Yeah, the Constitution existed, as did the First Amendment, but all of that case law that defends the First Amendment didn't exist yet. And so the Espionage Act was absolutely created, just as you say, Joe, not to regulate espionage. That was the name it was given to give it a sort of veneer. But what was done was to cast it in such a broad way that dissidents would be drawn in. And that was the only way it was used in almost every case for years. At least 2,000 people were convicted under the Espionage Act, roughly in the period, say, 1917 to 1925, including, as you all know, Eugene Debs, one of the great leaders of the country.
And
protesting the draft.
Right, as was the big Bill Haywood, to really put an end to the Wobblies. And their anti-war efforts. There was one case we spoke earlier that I want to bring up, and that's the case of the masses. There was an espionage case brought up against Max Eastman, the editor, and another editor there, assistant editor, and John Reed. And that case was, I don't know if it was dismissed or they were convicted and it was thrown out. I think it was dismissed. Do you know of any other cases of journalists that were convicted at all? I mean, I have not been able to find that.
No. And at the time of the Pentagon Papers publication, the government was very careful to prosecute Ellsberg and Russo, Dan Ellsberg, but not the New York Times. Now, the New York Times was given thousands of pages of the Pentagon Papers study. And it had a team of editors and writers for weeks who edited it down so they could publish it. Obviously, we didn't have the internet then, so they had to reduce it in size. But we prosecuted Ellsberg and Russo, not the people who actually disseminated it. This is the first time a journalistic organization is being prosecuted. And really, it's a type of selective prosecution.
Right.
No one dared to go after the New York Times or the Washington Post or the Boston Globe, all those papers that published the Pentagon Papers. But Julian Assange, they're going after. Right. And there's a clear case of selective prosecution here. But the precedent is astonishing. All journalists should be quivering, frankly, at the thought that their source could lead them into a prosecution.
Joe, you've written about the Espionage Act. He wrote a tome. It was like 5,000 words. So what else did you see in his article that wasn't in that long article that you wrote, that Bruce published the other day, or you published?
A couple of, it was actually 13,000 words, and there was a few things in Bruce's article that were not in there. One of them is the issue of jurisdiction. Up when it was written in 1917, the Espionage Act covered any activity in the United States, any territory of the U.S., or on the high seas. And there was this incident in Warsaw in 1958 or 59 when an American diplomat was found in bed with another woman by Polish security services. They showed him the photographs and they blackmailed him to get documents out of the embassy. When he left U.S. territory to go onto Polish territory to give those documents over, he could not be charged under the Espionage Act. That incensed one member of Congress who got that part of the law dropped. But as Bruce points out, they never replaced it with anything, so it's not exactly clear what the jurisdictional issue is. And Bruce, in the piece, goes through some text, some case law to show about how jurisdiction works in the U.S., including Supreme Court decisions. Bruce, can you talk a little bit about the jurisdictional issue for Assange and why you think that the U.S., under the Espionage Act, does not have jurisdiction over Julian Assange?
Yeah, it's what the Supreme Court has said very clearly is that a statute must clearly and expressly give the U.S. extraterritorial jurisdiction in order to prosecute. And those words were chosen by the court really for due process reasons. Assange, sitting in London or in Reykjavik, believes he's not within the scope of U.S. law. Yet the U.S., using a vague statute, now attempts to haul him into the U.S., and he's sitting in jail in Britain for 2 years now during an extradition proceeding for that very reason.
4 years.
Well, yeah, he had earlier a bail jumping period, but I was just looking at yes, he's there almost 4 years. And so what the court has said is you can't do this. Congress can't reach out across the seas unless Congress specifically says so. And the Espionage Act has absolutely no language that would allow that inference. It says U.S. facilities and U.S. bases can be the subject of a prosecution if someone takes records or documents from them. There's not the slightest hint that sitting in London or sitting in Reykjavik or anywhere else, and you get an email from Chelsea Manning with documents, that will lead you into prosecution in the U.S. Now, let me give you one example of how it works. There's something called the Foreign Corrupt Practices Act, which you may have heard of, and that regulates bribery in foreign countries. And what the U.S. says in that law is that if the money for the foreign bribe goes through a U.S. bank, or if the company that pays the bribe has stock trading in the U.S., then that person giving the bribe or the company can be prosecuted here. In other words, we create this geographic specific connection to the U.S. in the law to gain extraterritorial power. None of that exists in the Espionage Act. There's really no legal basis for the U.S. to prosecute Assange. And this entire extradition proceeding is really based on the absence of jurisdiction.
Right. Joe, you got a follow-up on that?
You mentioned the Pentagon Papers. Nixon actually did impanel a grand jury in Boston to try to get the New York Times editors and reporters indicted, but it was when, in the Ellsberg case, it was discovered that the government, the FBI, had been eavesdropping on his phone calls. The New York Times reporters asked whether they, too, had been eavesdropped because they were speaking to Ellsberg, and that's when the case was dropped. So a misconduct in that case ended the prosecution of the New York Times because the Espionage Act, what the Supreme Court decided was that there's no, you cannot stop publication before. In other words, the government cannot tell a newspaper you can't publish something. Prior restraint not allowed. However, after the fact, the Espionage Act allows prosecution of journalists, and Nixon tried that, and it failed there. And I want to ask Bruce again what happened in the case of Julian Assange when UC Global, the Spanish company, was spying for the CIA, as we know from the Madrid case against UC Global, and they were spying 24/7 on Assange, including his conversations with his lawyers. So isn't that grounds to throw out this case just the way Ellsberg's case was thrown out, Bruce?
They say like art imitates life. It's amazing how one case seems to imitate the other. The government just can't restrain itself. In the Pentagon Papers case, the Nixon administration believed that as long as you can spy on someone, you'll get something useful. And, of course, that killed that whole set of prosecutions. Judge Burns said it's unjust to continue with the government spying on the man's private calls while he's a defendant. And that's exactly what happened to the global entity. They were retained by the government to actually not only listen in, but to actually take possession of cell phones and devices when Assange's lawyers went to visit him at the Ecuadorian embassy. And so they were actually, according to the allegations that have been filed, they were actually entering devices to gain information about communications with Assange. And so we have exactly the same problem playing out where the government knows he's a target of their investigations. And I think they even had indicted him by then in 2018. And they were still engaged in espionage or surveillance, rather. So I think the same fact pattern would apply here, that fundamentally the government's given itself an unfair advantage in the prosecution by violating the law. Now, they may turn around and say, well, we're only prohibited from wiretapping and doing surveillance without a warrant in the U.S. We're not barred from doing that abroad. I don't think that's going to play out in the courts.
You don't?
Due process applies. No, I don't think so.
I mean, in that courtroom in Alexandria, Virginia, maybe on the federal court, maybe in the appellate division, but that's conservative there as well, and then the Supreme Court. I mean, it's going to be difficult because tell me the approach you would take as a defense attorney if you were representing Assange here. Where would you start, and where would you go with it?
Well, the first thing I do is you probably have to go to the Alexandria court. Look, I don't have a bias against judges one way or the other about their backgrounds. Often conservative judges are very strong on civil liberties issues because the Constitution is very clear in those areas. Where federal judges may differ with more liberals is where the contours are more fuzzy. And so, but I don't think conservative judges are not likely to apply the Constitution correctly at all, to be honest.
Yeah.
In fact, some of my civil liberties cases have done better with Republican appointees as judges. So I'm not sure that matters as much as though we may assume it would be an issue. I would start out with jurisdiction. I would move to dismiss this on the grounds there is no extraterritorial reach, and therefore Assange should not even be brought to the U.S. And he's not really a fugitive in any real sense. He was never here. He's not a U.S. citizen. The offenses were not committed here. So I think Assange has the right to go to court now, even while in London or in England, and move to dismiss. I'd start with the jurisdiction. Right. Then I would move to the vagueness of the statute, because that is a clear due process violation. It's never been tested in any court decision, either the First Amendment end of it or the due process end. So Assange has a chance to really probe new ground and make this point.
Let me just make a point. Randy Credico, live on the fly here. We're talking with Professor Bruce Afran, who studied at Brooklyn Law and at Binghamton, where he got a degree in history, and the managing editor, Joe Lauria of Consortium News, the busiest guy in the business. Joe, you really are. It's amazing how much that was I just remember it was a 13,000 word piece that you wrote. It was a book. Joe, but I'm going to hand it over to you. You're up.
Yeah, thank you, Randy. Bruce mentioned the issue of the fugitive, and I want to just give it more explanation what that means. If to try to go to court now in Virginia while Julian is still in Belmarsh and his extradition case is still up for determination, maybe by the High Court, it would mean bringing this motion now while he's still in Britain. But the U.S. could argue, or the U.S. prosecutors could argue, that Assange is a fugitive, and therefore it doesn't apply. A doctrine called fugitive disentitlement. And Bruce, you don't agree with that. Tell me more about why that wouldn't apply here, in your opinion. Why he'd be able to do it now, to go now to the court to try to throw this case out, and not wait for him to be extradited here.
Yeah, there's something called the disentitled fugitive doctrine. And basically, as Joe just said, that means that if you're not within the U.S. and you've absented yourself, you don't have the right to dismiss the case until you show up and accept the court's jurisdiction. That's the normal rule. But it has never been applied to a person who's not a U.S. citizen, who didn't live in the U.S., and who was not here when the offenses were committed, and who didn't flee the indictment. Julian Assange was never even here when he was indicted. He actually came in 2010 after the WikiLeaks publications. He wasn't under indictment, and he left in the normal course after a press conference. So he never fled the U.S. He's not a traditional fugitive. And the cases all speak of people who deliberately leave the country to avoid an indictment. Assange never did that. Julian Assange is not a fugitive in that sense. So in my view, and it's something that's sort of new because it doesn't happen very often in law, in my view, he can go to court right now, staying in England, and have lawyers in Alexandria in federal court make these motions. And I got to say, from his point of view, he's probably better off being where he is than being in the tender mercies of federal isolation in a supermax prison while he awaits these motions in Alexandria. So I think that he should be making these motions now. I think he has the right to. I don't think he's a fugitive as the law understands it.
Right.
I hope that's a good explanation. I know some of this is a little esoteric for listeners.
Another point you brought up was the conspiracy. The conspiracy to on computer fraud. Can you walk us through that?
Yeah, that's really one of these make-weight charges that the government uses in case it loses what is probably a very weak case under the Espionage Act. And so basically the Computer Fraud and Abuse Act makes it illegal to enter without authority a computing system or device. And so they're suggesting that he conspired to do that with Chelsea Manning by instructing Manning on how to use certain types of coding to enter a system. And the case, it seems, from what I know, is really very weak. It appears, from what I heard, they were talking about something else entirely, basically some sort of music sharing rather than having anything to do with this. And merely saying one might know how to do that is not conspiracy. Right. I think this is probably a very weak case, and it's really what we call a make-weight that the government sometimes uses just so it has a backstop. Because the main case in the Espionage Act probably won't survive, I think.
All right, we just have a few minutes left. Joe, I want to ask you, I'll give you both a couple of minutes. You're feeling, you saw the Shiptons. Are they upbeat? Do they feel that the momentum is with this movement to free Assange, or are they pessimistic?
I think John Shipton is as optimistic as I've ever seen him, and it began 2 weeks ago when the Australian ambassador to the United Kingdom went to actually visit Julian Assange in Belmarsh prison. And that's something that had not happened for 4 years. So that was done on the request of John Shipton. So it shows some movement incrementally by the Australian government, which has been doing very little despite certain statements about this being enough, that the case should come to a close. They never specifically said he should be released. They just said it should come to a close. The foreign minister, Penny Wong, in a appearance at the National Press Club in Canberra just a few days ago, again, dodged all these issues as she did in Parliament when Senator David Shoebridge directly asked whether Albanese, the Prime Minister, had actually spoken to Biden about this. So we still don't know whether he directly raised it. Albanese later said that he's talking at the appropriate level to American affairs. What is the appropriate level? So, but in any case, this movement and the meeting he had yesterday, and I spoke briefly to John after his meeting with the Mexican president, he was very upbeat about that. He said the guy has a lot of guts. He used another word rather than guts, and to stand up to the United States. Now, a president of Mexico has in fact contacted Biden. I don't know how many times, what the response was, if any, but they're making an effort, and there are other deputies and members of parliament around the world, in Germany, in Britain, even in Australia, and now this letter of 7 members of the U.S. House of Representatives to the Attorney General to drop the charges against Assange. That kind of thing, with the argument that Bruce is making now, and other people who study this case see that it's really based on very, very little. And I want to ask Bruce, if I can, where you think the Supreme Court comes in this. You mentioned the Supreme Court in the piece that they already made a ruling that was applied to, I believe, the the jurisdictional issue. But don't you see this case being ripe for the First Amendment being challenged here, the First Amendment conflict with the Espionage Act?
All right, Bruce, you got 1.5 minutes to answer that. All right?
Yeah.
Great. I'll do it then. I think it's absolutely ripe for the Supreme Court. These issues have never been tested under the Espionage Act. I think every case that's been resulted in a conviction was a plea, and nothing has ever gone to the court at this level. I think it will go to the court if he comes back to the U.S., and I think there's a very strong chance the court, actually because it's a conservative court, will probably rule in his favor because the Constitution's contours clearly protect Assange in this instance. I'd like to say this. I think Australia ought to be defending its citizens. I think many countries are affronted that the U.S. presumes we can reach across and snap someone back here without any actual law that says so. I think Assange's English lawyers ought to be raising the issue of jurisdiction in the U.S. If they can convince the English court that under U.S. law there's no extraterritorial reach, Assange may go free in England. Wow. So I think it's going to get to the U.S. Supreme Court if he comes back here. I think there's a lot of room in the English court still for him to argue. And frankly, diplomacy may resolve the case.
We hope so.
Sometimes in these cases, yeah. Sometimes you serve a minor sentence in your home country, 6 months, and that resolves it.
Well, listen, his health is not that good, and he wouldn't be able to go through the district court and then appellate court, and it would take years and years, and it'd be a posthumous victory for him. So we got to get him out of there as soon as possible, by all means necessary. I mean, legally. I'm not trying to break him out. All right, legally. All means necessary. Legal. Yeah, we have to just continue the pressure. Joe Lauria, I look forward to seeing you in D.C. In the coming days or coming weeks when you're back. And thank you so much, Bruce. It was very insightful. Thank you both for being part of this show, and it was very enlightening. And we're going to say goodbye to both of you. Bye, Joe. Goodbye, Bruce. All right.
Thank you. Bye-bye.
All right.